Hi, everyone. Thank you for joining us today for our webinar titled, Could My Company's Website Violate the Americans with Disabilities Act? I want to go over a few housekeeping items before I turn the presentation over to our partner here, Chuck Marion. Your audio today should stream automatically on entry through your computer speakers. But if you're unable to stream your audio today, you can click this phone icon that I have highlighted here, and a dial-in information number will be sent to you. We also encourage you to send us questions today through the Q&A button at the top of the screen, and then you can type your question down below. You can also download the PowerPoint slides by clicking on the File button and then selecting Save as a PDF type. And we are offering CLE credit through our accreditation program, and it is available in California, New York, Pennsylvania, New Jersey, and Virginia. So if you would like to apply for CLE credit, please contact me after the program, and my email address is included here on the slide. And with that, I'll turn it over to Chuck, who is a partner here in our Philadelphia office. Chuck?
Thank you. Hello, everybody. I'm Chuck Marion, and as Kristen just said, I'm a partner with the law firm of Pepper Hamilton in Philadelphia. Pepper is a full-service firm. We have about 520 lawyers in 13 offices throughout the United States. My particular areas of practice are in business litigation, intellectual property litigation, and franchise litigation. Joining me today on our panel are Jeff Goldman, and Jeff is a partner in Pepper's Los Angeles and its Orange County, California offices. Jeff is also a member of our commercial litigation practice group, and he focuses his practice in the areas of commercial litigation, labor and employment matters, intellectual property disputes, commercial litigation construction litigation, and defending state and federal consumer class actions. And last but certainly not least, we have Elena Chernow. Elena is Director and Legal Counsel with Duncan Brands, based in Canton, Massachusetts. Duncan is the owner and franchisor of Dunkin' Donuts and Baskin-Robbins restaurants, of course, throughout the United States and throughout the world. And at Dunkin', Elena is responsible for reviewing and approving all of Dunkin's marketing and advertising, and for food labeling issues and trademark matters. Prior to joining Dunkin', Elena was Senior Corporate Counsel with Ocean Spray Cranberries, Inc. So we're delighted to have her join us today. This webinar is going to cover the following three topics. First, whether the Americans with Disabilities Act applies to businesses and institutions' websites. Second, what companies and institutions are doing, can do, and should be doing to limit their liability and exposure for claims that their websites are in violation of the ADA. And then we're going to take a look at some of the trends and recent litigation we've been seeing in this area, both enforcement actions, certain claims, and of course lawsuits that have been filed in various jurisdictions asserting that websites violate the ADA. Now, way back in 1990, when the Americans with Disabilities Act was enacted, of course, there was no widespread use of the internet, and there was really no e-commerce as we know it today. The law provides that places of public accommodation must ensure equal access to the goods and services they offer to disabled individuals and everyone. And the statute defines public accommodations as being various types of physical locations, such as hotels, restaurants, retail stores, movie theaters, and so forth. The Act does not mention websites or provide any guidance or standards for making websites accessible to disabled individuals. About 10 years ago or so, we began seeing some claims and lawsuits being asserted arguing that websites are public accommodations, especially those that offer goods and services, and that they need to be in compliance with the Americans with Disabilities Act. The claims were being brought on behalf of visually impaired or hearing impaired and other disabled individuals who said, we can't read all the information or hear all the information on the site, we can't navigate around the website, so it's in violation of the ADA. In 2010, the Department of Justice began soliciting comments on proposed regulations to govern website access. Well, that process was supposed to conclude in July of this year, next month. However, the Department of Justice earlier this year announced that they had extended their comment period and rulemaking period for another 2 years. So we won't really see any guidance or rules from the Department of Justice until at least 2018. However, in the meantime, the Department of Justice has been fairly active in certain investigations, enforcement actions, and in filing amicus briefs and position statements in pending litigation brought by private individuals and they've taken the position that the ADA does apply to websites. Now, in the last year or two, we've really seen a lot more litigation in this area. We're going to discuss some of these cases that have been filed in the last year or two later in the program. Jeff Goldman and I, who are on the call, have each had a number of matters come up in this area and have handled some of these claims for our clients. So we have some firsthand experience with them. I also wanted to mention, while this is not the specific subject of our program today, that some of the recent demands and lawsuits we've been seeing in this area have also included privacy-related claims. Basically, that visually impaired or other disabled individuals are unable to access, review, and agree to a website's privacy policy. And they're therefore not aware, for example, that certain websites gather information that's personal or track where they go on the site and so forth. They've asserted claims that this, of course, violates their privacy rights under certain state consumer protection and computer trespass statutes. When it comes to litigation, the vast majority of cases have settled at a very early stage. Those cases that have gone to a ruling, whether it be a motion to dismiss ruling or summary judgment, in those cases, the courts have actually come to differing conclusions. There's been a bit of a split among the circuits as to whether and when the ADA applies to websites. As a result, we have basically a gray and uncertain area for companies and universities and other institutions. And the plaintiffs' firms have kind of wised up and taken advantage of this uncertainty, and they've sent a lot of demand letters out seeking settlements or filed lawsuits against various companies and institutions. They often will say they had an independent expert go and review the website in question and found various ways it's not compliant with the ADA. And while the ADA is an injunctive statute, it doesn't provide for monetary damages. If the plaintiff prevails, he or she can obtain their attorney's fees. So there is some exposure there. And we've seen, and we'll talk about this later, we've also seen in some of the lawsuits other claims, apart from violation of the ADA, being asserted under state statutes and so forth that do have a monetary damages component to them if the plaintiff prevails. Also, while the Department of Justice is delaying a bit its rules in this area and its guidance, as I mentioned earlier, it has, in some cases, commenced enforcement actions against companies, and it can and does have the authority to impose penalties for violations, which can be substantial. Now, we've seen in the litigation to date a couple of things. First of all, it is difficult to get these cases dismissed at the motion to dismiss stage, at an early stage. Also, the judges have not been willing to stay cases, basically to put these cases on hold while we wait for the Department of Justice to come up with its rules. So they've denied motions to stay in these cases. So if a company or an institution wants to dispute or defend one of these claims, they're going to have to litigate for a while and, of course, can spend a considerable amount of time and resources doing so. Expert witnesses will be necessary, outside counsel, and so on. And, of course, as with any litigation, there could be some negative publicity. But the trend overall, certainly it seems as though we are heading toward a point where most websites that engage in some type of e-commerce or offer some sort of services will be required to comply with the Americans with Disabilities Act. So best practices certainly dictates that companies should at least look closely at their websites and consider taking steps, reasonable steps to make their sites more accessible and more compliant. Now, assuming that a company or institution does want to go ahead and do that to make its site as compliant with the ADA as possible, how does it go about doing so? Jeff, can you talk about, are there any standards by which websites are judged in terms of complying with the ADA?
Sure, and thanks, Chuck, and hello to everybody who's joined us today. It's our pleasure to be speaking to you. There are standards. As many of you are probably aware, the most known one are the Web Content Accessibility Guidelines 2.0 AA, or the WCAG. Those are standards that were published by the Web Accessibility Initiative of the World Wide Web Consortium back in December 2008, and they've kind of become not necessarily the de facto standard, but the standard that most courts and most plaintiffs' lawyers are going to be pointing to say you have to comply with. Certainly the DOJ has. The standards offer 3 levels of compliance, A, AA, and AAA. As a general matter, all sites really should be at least in compliance with the A standard. AAA is generally considered optional. AA is kind of the standard that most of the courts and the DOJ are going to be pointing to going forward. The WCAG defines how to make web content more accessible to people with disabilities. That includes visual disabilities, auditory disabilities, physical disabilities, other disabilities. It's very broad, and really it focuses on the 4 main categories you see before you. I like to use the acronym POUR, P-O-U-R, for perceivable, operable, understandable, and robust. In terms of perceivability, that means are there text alternatives to non-text content? If you have a picture, do you also have a way for someone who is blind or partially sighted to understand what they're looking at? If you sell a bag, is there text that says it's canvas with a latch? In terms of operability, for example, are you able to navigate the website via keyboard as opposed to mouse? Is the content understandable? Can it be read and understood? Do the pages appear and do they operate in predictable ways? And then finally, robust. Robust is a broad and frankly relatively vague term, but generally that means does the website maximize compatibility and use assistive technologies? For each of these standards, the WCAG has promulgated detailed guidelines, minimum requirements for conformity. Another set of standards that's out there was promulgated by the U.S. Access Board. It's somewhat less rigorous than the WCAG standards, but they're called the Section 508 standards. They apply to federal agency websites. You sometimes will see that term being used in the cases along with the WCAG. We've seen some other standards. For example, Netflix recently reached settlements with the national and state-based councils for the blind, agreeing that its mobile app would comply with the British Broadcasting Corporation's Mobile Accessibility Standards and Guidelines version 1.0. Interestingly, the Department of Justice recently issued a supplemental notice of proposed rulemaking concerning Title II. As Chuck mentioned, they've delayed issuing any sort of rules on Title III until 2018. But what they've now said is they want to solicit comments on Title II, which applies to state and local governmental websites, and I think they provide some good guidance as to perhaps where we're going to be headed in the private realm. Some of the highlights that we've put up here on the PowerPoint, first there's a suggestion that state and local government websites will have to conform with WCAG. They'll be given at least a 2-year grace period to get in conformity therewith. Which is interesting. We've seen some settlements with the DOJ and private entities providing for that 2-year standard as well, so perhaps that's where we're going to see the private website standards headed. There is the possibility of expanding the ADA to web content that's provided by third parties on state or local government websites. They're soliciting commentary on that. That's an interesting development. A lot of the cases that we've seen, particularly out here in the Ninth Circuit, make clear that content doesn't need to be made accessible, rather the availability of the content needs to conform to the ADA. For example, a bookstore needs to comply with the ADA to make sure people with disabilities can access the bookstore, but they don't necessarily need to provide all of the books in Braille. for those who are blind. This would be an interesting change if it's applied to the private realm. Think, for example, subscription-based content providers, blogs. Are they suddenly going to have to provide everything on their websites in audio form? Our podcast is going to have to provide written transcripts. It'll be interesting to see where that heads. Educational institutions are discussed in the supplemental ANPRM. They're considering requiring institutions to make all contents available to the public, not just the students on the websites, and they're considering making them apply with WCAG standards. On the other hand, the Department of Justice is considering some exceptions or exemptions and is soliciting comments about them. For example, small public entities. There's a suggestion that perhaps small public entities wouldn't have to comply with or strictly comply with WCAG. It defines small public entities as a small governmental jurisdiction, which is defined under the Regulatory Flexibility Act of 1980, and it's defined as governments of cities, counties, towns, townships, villages, school districts, or special districts with a population of less than 50,000. The Department of Justice is also seeking input as to whether these entities, these small entities, should have 3 years as opposed to 2 years to get into compliance with WCAG. They're also considering the possibility of certain defenses, such as an undue burden or fundamental alteration of the services, programs, or activities of the public entity. And then some other issues that have come up there, and again, these are all possibly going to pop up in the Title III context, how to measure WCAG compliance. They want to know what people think about that. What percentage of the website needs to be compliant? 100%? Something less? Is it going to be measured by time or by content? I'm sure most folks here understand that websites are constantly being updated, changed, etc. What if there's downtime? What if there's time that a certain page is not going to be accessible to the public? These are all things that the Department of Justice is looking at and will be considering in promulgating new Title II regulations and possibly Title III regulations. Also, they're going to be asking about whether mobile apps should be included. I'm sure that's of interest to a lot of our listeners and viewers today. Do mobile apps have to comply with WCAG? I'm sure that you all realize that the WCAG's requirements are not exactly easy to meet, and to comply with them is not an insignificant or an inexpensive task. What I think we should do now is turn over to Elena, who has had to deal with this issue at Duncan Brands. Before I do that, I'll just point out kind of as a summary of the standards and guidelines that WCAG and Section 508 do offer guidance and best practices, but they don't offer strict solutions. They're really technology neutral, and they do allow for interpretation and for leeway. Chuck, do you want to introduce Elena?
Well, yeah, I agree, Jeff. I think, Elena, I know you've had some personal experience with this issue at Duncan. Tell us what your experience has been. You know, how did Duncan go about analyzing its site, determining what it needed to do to make its sites more accessible to disabled individuals?
Can you hear me?
Yes.
Okay, awesome. So the first thing we did was acknowledge that we had no internal capabilities or skill set in this area. And we promptly hired an outside consultant who I can recommend. It was the National Center for Science Accessibility in the Media, which is part of WGBH, which is the PBS of New England. And they have the Carl Ruth Shapiro Center, and this is their area of expertise. And they came in, and we did this for both brands, both Duncan and Baskin, and evaluated our websites. And they gave us written reports. And what was nice is they then came down and met with both the website developers and the marketing team. So the marketing team will never do anything like this willingly. They have to be cajoled and threatened. And, you know, their argument is, well, the DOJ doesn't require it. Okay, well, that's not really the standard we're working on in the world now. So I think having people come down and meet with them and walk them through what's really necessary and walk them through the different tools that's available to evaluate whether your website is accessible was a huge win for us from the legal department standpoint, because it made it seem less scary. for them. You know, they're still not amused, but they're more able to execute what we're asking them to execute. So closed captioning, not putting images on images. They're working on, you know, making sure that it's compatible with many different types of readers, because it's not just one that's the standard. We had to do a lot of work of navigation on our website. And I don't know if you can go to the next page or the page after. Duncan's website's fairly busy. Go one more. And there's a lot, as you can see, there's a lot of moving parts within the website. And the consultants were very helpful to tell us that if you're blind, when you're using readers, it's very hard when multiple things are moving at the same time. So they were able to help us understand how people who are impaired go about viewing and using your site, which for people who are not impaired was very, very enlightening. If you go back one slide, if possible. So we also, unfortunately, learned that our core colors, which are pink and orange on one brand and light blue and pink on the other, are really not the most user-friendly colors for the visually impaired, but they are the brand standards, which obviously makes our marketing people very nervous that the legal department's going to play in their brand standards. But we did come up with a solve, if you want to go to the next slide again, that there is a high contrast mode that you can program your sites to operate within. It takes away the color issues, and it allows the text to be read more efficiently and clearer. And you also have the option of programming it to increase the font size as well, so that when someone has this mode, their toggle on, it will increase both the font and will increase the font size. So that was an incredibly helpful tool that we learned how to use. And it's still, unfortunately, a complete work in progress for us. Different parts of the site have been brought up to date. Other parts are a little bit farther behind. But the goal is for us to really move in the next 3 or 4 months to relaunch the Duncan side and get it up to level AA. And on the Baskin side, we're a little bit closer, but the website's a little bit less complex with less moving parts.
And Elena, I recall when we were talking about this program that there's certain parts of your company's websites that are perhaps operated by third parties outside of Duncan. How do you deal with those pages of your site or those sections?
So it's interesting. Some of our vendors are ahead of us, and we link to sites that were already ADA compliant, and others were farther behind, and we are working on getting them up to speed, but we're contracting with new vendors to make sure that ADA compliance is part of their requirements. So it now goes out in our RFP. So if you are bidding on Duncan's business, you know that the standard you're going to have to meet is WCAG 2.0 AA, and if you're not capable, please don't bid on our business. So we've been taking care of it from a contract standpoint, and for the vendors who were there prior, you know, we've reached out to them. We've provided assistance from NCAM if they, you know, need some help in understanding what they need to do. And they've all been very accommodating and willing to cooperate, which has been very nice. We haven't had any pushback.
Okay, good. And we have on our screen a line about seeking indemnity for any claims related to pages or sites operated by third parties. I don't know if you've had any experience with that issue or tried to get that kind of indemnity.
You know, so our standard contracts are, as you would expect, you have to comply with the law. Now, this is a little gray area as to what the law actually is. We have fairly broad indemnification provisions. For the newer contracts, where we've been very specific as to what we are expecting, I would think if there was a breach, we would seek indemnification. We have not been put in that position at all, where we've had to look to any third-party vendors for indemnification.
Okay. And you raised a good point, too. With the law sort of up in the air, they would have a possible defense, of course, that they're not required to make the site compliant.
Right. So, but for future agreements where the standard is written in, I think we've been able to get a little bit broader language. But we also are now more aggressive in monitoring our partners as well. So we're not only monitoring our partners, but we have to monitor ourselves because, as Jeff pointed out, brands are putting up and taking down content, I would say, multiple times a week. And that requires a lot of training on behalf of the various agencies to understand that each new piece of material, you need to run it through the filter of compliance. You know, once you get the framework of the website up and running and properly coded is one thing, but the never-ending posting of videos and text messages and images, they have to be conscious going forward for basically the rest of their lives, that everything they do has to be viewed through this filter. I think that going forward is probably our biggest challenge, is resetting the mindsets of the various different agencies, which vary size, scope, and capabilities.
What about mobile apps? I saw on a couple screens ago an image of a phone, and you know, an iPhone or something with an app. Is Duncan looking at that at all?
We are, and we think it's, you know, from what NCAM has advised, that it falls under similar guidelines to the websites. There are some modifications that we're going to have to make, but as we launch new apps, the goal is to launch them compliant as opposed to have to go retroactive and fix.
Okay. Well, thank you, Elena.
It's a work in progress.
Well, it sounds like probably some good job security, because you're right, the websites change all the time, so we'll have a lot to look at. I'd like to now turn toward a discussion of some of the trends we're seeing in terms of litigation, claims, and enforcement actions. Apart from the delay on the Department of Justice's part in issuing guidelines, a big reason there's a lot of uncertainty in this area is that the courts that have looked at this issue have kind of come down different ways on different sides of it. On the screen, you'll see a chart of where, in the last 5 years, we've seen lawsuits filed asserting claims that websites are in violation of the ADA. There are clearly certain states where we've seen more activity, including California, Pennsylvania, New York. Florida's kind of coming up. For the most part, in those states, there tends to be one law firm primarily behind all these lawsuits and filing these lawsuits. But in any event, there has been, as you see, a lot of activity, and more as time goes by. Now, in general, the split that I talk about, for example, the 3rd, 6th, and 9th circuits, at least in past decisions, and the law, of course, is still evolving, but they've generally held that the Americans with Disabilities Act does not apply to websites which are not connected in some way with a physical location, such as a retail store. In contrast, the 1st Circuit and the 7th Circuit have generally held the opposite, that the ADA applies to websites regardless of whether there's a physical location as well. And I put on the screen the 9th Circuit again, but it seems to be becoming kind of the leading view, at least in some circuits, including the 9th, the 2nd, and the 11th circuits, kind of a sliding scale that the ADA will apply to a website if there's a sufficient nexus between the site and a physical location or space. For example, where somebody can make an order on a website and then pick it up at the physical store. Let me first start with my own state, Pennsylvania. We've seen a lot of cases filed in the last couple of years in the Western District of Pennsylvania Federal Court, again, primarily by one law firm, a plaintiff's firm based in Pittsburgh. Most of these cases have been filed against large retailers, insurance companies, and others that tend to have deeper pockets. And the claim is basically, it's a one-count complaint in most cases that the company or institution's website is not accessible to hearing or visually impaired individuals and not in compliance with the WCAG 2.0 AA standards. Typically, they'll ask for injunctive relief, basically that the site be brought into compliance, a declaration that it was out of compliance, and attorney's fees for the plaintiff if they prevail. Several of these cases have been consolidated and assigned to a very experienced judge known to have very good case management and administrative skills. And in following some of these cases and being involved in one or two, we've seen that judge kind of steer a lot of them toward ADR, toward a mediation or a settlement conference at an early stage. And in fact, most of these cases have been settled at a relatively early stage. There was one defendant, Harbor Freight Tools, that tried a little bit of a different tactic. They were sent with a pre-litigation demand letter. They tried to strike first by filing a declaratory judgment action in California, and the judge, and then they moved to dismiss the Pennsylvania action when it was eventually filed, saying, well, there's already a case pending in California where we've asked for a declaration. The judge in the Western District of Pennsylvania denied the motion to dismiss and found that the Harbor Freight basically was engaging in forum shopping and knew that, you know, the plaintiffs were in Pennsylvania, knew that other litigation was pending there, and there were some references to bad faith thrown around a little bit in the opinion. The judge basically took issue with what Harbor Freight tried to do and denied their motion. Let's move to New York. New York, there's been a lot of activity. It's a little bit more recent than Pennsylvania and some other states, and again, it's primarily one law firm kind of leading the way. In contrast to Pennsylvania, however, the cases at least pending in New York so far have not been consolidated, so they're kind of proceeding along on their own. As in Pennsylvania and other states, however, a lot of these cases are being settled at the early stage. In addition to the ADA claim in New York, we're seeing that the plaintiffs are bringing claims under related state statutes, the New York State Human Rights Law, the New York State Civil Rights Law, and municipal statutes such as the New York City Human Rights Law. And some of those statutes do have a monetary damages component, unlike the ADA. So we're seeing claims for compensatory damages in those cases also. Most of the New York cases were only filed, I'd say, in the last 2 or 3 months. So they're really, several are still pending. We'll see what happens if anybody, you know, decides to fight those and not resolve them at the early stage or not. Now in Florida, similar to Pennsylvania and New York, we see most of the cases being filed by one firm, and the cases primarily being filed in the Miami area, in the Southern District of Florida Federal Court. And in these complaints in Florida, in addition to the normal claims under the ADA for injunctive relief and attorney's fees, they tend to contain a little bit more specific allegations when it comes to what changes the plaintiffs believe should be made or need to be made to these sites and what relief they're seeking. For example, they've asked in these cases for a universal disability symbol to be on the site to direct the visitor to another page that provides information about disabled access, disabled individuals being able to access things on the website. And they've also asked for specific policies to be adopted by these defendants for their websites and for their accessibility. There has been a lot of interesting activity in California in the Ninth Circuit. Jeff, do you want to address that?
Sure. Thanks, Chuck.
Oh, hold on one second.
Yes, I'm just going to, sorry to interrupt, I'm just going to come on the line with 2 of the CLE words. So if you would like CLE credit, please remember these first 2 words, and then I'll come on later with the last 2. The first word is website, and the second word is Hamilton. So again, that's website and Hamilton. Sorry, Jeff.
No problem. CLE credit is important. So the Ninth Circuit, in particular California, is, like a lot of other things, different than the rest of the country. So what I want to do is kind of talk about what the Ninth Circuit standard is, and then some holdings from recent federal courts, and then some state court holdings. As Chuck alluded to earlier, in the Ninth Circuit, there has been an appellate court holding that the term place of public accommodation in the ADA requires, quote, some connection between the good or service complained of and an actual physical space. That case is Wire versus 20th Century Fox Film Corporation. And while that was not a website case, it does stand for the proposition and has been held by the courts below, as you can see, that a pure website not connected to a brick and mortar location is not going to be subject to the ADA, at least not in the Ninth Circuit. In Wire, it involved an employee or a former employee of 20th Century Fox. She sued her company, and she sued her company's insurer based on a failure to provide some mental disability benefits, and the district court granted judgment in favor of the defendants. It was appealed, and the Court of Appeals affirmed. And one of the reasons that they affirmed is they said that assuming Title III could apply in the employment context, that the place of public accommodation needed to be physical space, and that an insurance company offers benefits but doesn't necessarily have a physical brick and mortar that benefits are tied to. And it acknowledged that while the insurance company may have a physical office, someone complaining of a denial of benefits is not complaining about denial of access to the insurance company office, but something else. And so, like I said, that has been glommed onto by several courts in the Ninth Circuit. Earl versus eBay and Cohen versus Netflix are two big ones. I consider them to be particularly important because just last year they were affirmed by the Ninth Circuit in separate opinions, unpublished opinions, so they're not precedential. But what that shows is that the Ninth Circuit, even though it's well aware of the brouhaha over whether the ADA applies to websites that are not connected to brick and mortar locations, is still sticking with the holding of Wire versus 20th Century Fox. That suggests to me that it will continue to have that belief until and unless the ADA is amended to specifically apply to websites. We've seen other cases that involve a mixture of pure website and brick and mortar connections. For example, in the Redbox case, the plaintiff complained that both Redbox Digital, which is just purely online, and the Redbox kiosk business were violating the ADA. And the court there held that Redbox Digital was not subject to the ADA based on Wire, even though there was the availability of a bundle where you can get Redbox Digital and access to 4 different discs per month at a kiosk, which the court held was subject to the ADA. That wasn't enough to subject the website to the ADA. So as Chuck mentioned before, there's a bit of a sliding scale that we're seeing at issue. The bigger case that most of the plaintiffs are pointing to is the National Federation of the Blind versus Target Corporation, which was in the Northern District of California. And what that case held was that if there is a substantial or a significant nexus between the website and a brick and mortar location, then the website can be subject to the Americans with Disabilities Act. For example, in that case, the website allowed customers to refill prescriptions, to place orders for photos, for pickup in stores. It provided store locations and hours, amongst other things. So the big question is, as yet unanswered definitively, is what is the degree of connection and entanglement between the website and the brick and mortar store that will trigger application of the ADA to the website, at least here in the Ninth Circuit? What it appears to be is that the websites that have absolutely no involvement with brick and mortars are not going to be subject to the ADA, at least out here. If there is some connection to a brick and mortar, and it has to be apparently more than just a bundle, as it was the case in the Redbox matter, it might be subject to the ADA. However, if it's so integrated with the brick and mortar location that a disabled user would be deprived of full use and access to the brick and mortar by virtue of the website's failure to be accessible, then the ADA may apply. And making all this even more muddy is that all these opinions are district court opinions, not Ninth Circuit opinions, so they're not going to be binding upon other courts. I'll transition now to the state court arena. There's really a lack of California state law, binding state law on this issue, but I'll point out a recent summary judgment victory that a plaintiff had against a defendant in a claim for violation of both the Americans with Disabilities Act and our state law equivalent in California, the Unruh Act. That was Davis versus BMI, BND Travelwear. Up on the screen now, you'll see that the Unruh Act provides all persons within the jurisdiction of the state are free and equal, and no matter what their disability, are entitled to the full and equal accommodations, advantages, facilities, etc., in all business establishments of every kind. The plaintiff prevailed on summary judgment in that case. Now, interestingly, the plaintiff said that they tried to access a website that was connected to a brick-and-mortar location 20 times, and thus sought $4,000 per violation. What the court found was that there was a violation of the ADA and the Unruh Act, but only $4,000 in damages were awarded. You don't get to go back to the website 20 times and say I was discouraged each time, apparently, according to this judge. There was some injunctive relief also. So what may seem like a Pyrrhic victory, leaving the injunctive relief to the side, just speaking monetarily wise, may not be so Pyrrhic, because the plaintiff's counsel has now moved for attorney's fees in connection with that case. The hearing is going to be later this month on it, but they're seeking in excess of $118,000 in attorney's fees. Something to bear in mind in deciding whether you want to update your websites or not. At least one court, by the way, has held that both this Unruh Act and another California state statute, the Disabled Persons Act, also applies to websites without any nexus whatsoever to brick and mortars. So, you know, maybe a little bit of 6 of one, half dozen of another out here. Even if the ADA doesn't apply, you still have a concern about the Unruh Act and the Disabled Persons Act applying. Now, there are defenses that, you know, can be raised. I'm not sure some of them are raised in any of the cases we've discussed. There are standing issues, there are damages issues, et cetera. But these are statutes that everyone needs to be familiar with and understand that they can apply to your website out here in California. By the way, the case that held that the Disabled Persons Act and the Unruh Act applies to websites without a nexus to a physical location was also the National Federation for the Blind versus Target in a subsequent opinion. Now, we have seen these cases not just in California, not just in the Ninth Circuit, but elsewhere. And what I'll do now is talk about a couple of those cases that highlight the split between the circuits that we were discussing earlier as to whether ADA applies to websites or not. In Vermont, for example, the National Federation for the Blind sued Scribd. In that case, the plaintiff claimed that the defendant's website and apps, which offer reading subscriptions, services at the digital library, kind of like a Netflix for books. And they said it was inaccessible to the blind because it lacked non-visual means of operation. Scribd argued that their website was not a place of public accommodation, that the ADA does not apply to the website, and they moved to dismiss. The court reviewed other courts' decisions, including some of the cases I just mentioned, interpreted the statute, and concluded that a web-only business is a public accommodation that's required to comply with the Americans with Disabilities Act. It found that excluding businesses that sell services through the Internet from the ADA would run afoul of the law's purposes, frustrate Congress's intent, and concluded that Scribd services fall within at least some of the categories of public accommodation under the ADA, such as the service establishment and the library. Interestingly, that was a magistrate judge's opinion. It was appealed to the district court. The district court affirmed it, and it did so after the Ninth Circuit issued its opinions back in 2015, affirming the eBay and the Netflix case, and just disagreed with it. So again, there's a split between the circuits. That's the Second Circuit. Again, Massachusetts is another case. There's another case that we've seen discussing whether the ADA applies to websites. That was National Association of the Deaf versus Harvard and MIT. This is important for those of you who work for universities or in the educational realm. In that case, the lawsuits were filed in 2015, claiming that the university's online video programming was not closed captioned in violation of the Americans with Disabilities Act. The university moved to dismiss or stay while the Department of Justice investigated and developed its guidelines and rules. That motion was opposed, and in fact, the DOJ joined in opposing those motions and filed statements of interest, arguing that courts are well equipped to resolve website accessibility issues. The magistrate judge, I believe, has recommended that the judge deny the motions. The university has objected to that recommendation, and now we're waiting to see what the district court judge does there in Massachusetts. So I think the takeaway from the cases that we've just discussed, both in Pennsylvania and elsewhere, is that the standards appear to differ depending on where you are, which is not very helpful if you have a website that's everywhere. Chuck?
Thanks, Jeff. So I wanted to just discuss somewhat briefly. So as we mentioned, most of the litigation that's been filed to date has been settled before any decision is rendered by a jury or a judge. What types of terms do we typically see in these settlements, or what types of issues come up? And we actually do have a question about if the information is not confidential, can you comment on the size of settlements? Unfortunately, the cases that Jeff and I have been involved with that have been resolved on a confidential basis, so we're not at liberty to talk about that. But let me get to that in a moment. But first of all, you'll obviously see demands and terms in settlements that the site in question, the website in question, or websites, because sometimes a business will have multiple sites, that they be brought into compliance with at least certain standards. Maybe it's the WCAG 2.0 AA that we mentioned, or that seems to be the most common one, actually, that the plaintiff's lawyers are focusing on. But it might be those Section 508 standards that Jeff mentioned. There'll be oftentimes a demand that the plaintiff or the plaintiff's expert be allowed to go on the site at future dates post-settlement to audit or monitor the site to make sure they're still in compliance. I've seen some defendants resisting those types of obligations or requirements, but that is often demanded. Of course, a business engaged in best practices will monitor its site anyway on an ongoing basis to make sure it's as in compliance as it can be. A lot of times you'll see that the plaintiff will demand that a defendant adopt some sort of policy in its company that its websites will be accessible to disabled individuals. You may see a demand that the defendant train its internal personnel on making sure that anything they post on their websites be accessible to everyone and to different reader devices, like Elena mentioned earlier. Of course, the payment of counsel's fees is usually a component because that is allowed under the ADA, under the statute. And, we have seen some examples. In terms of the amounts, there are some Department of Justice settlements where we've seen, some parties agree to pay a certain amount as a penalty. But generally, the private, litigation settlements to date, for the most part, I have not seen any numbers released. So I think, unfortunately, I can't shed too much light. But Jeff and I have had some experience, and, as I said, most of these get resolved in the pretty early stages before a lot of time and expense and expert fees are run up. Jeff, do you want to comment on the last point, whether there might be any ways to avoid, if you do settle one of these claims, is there anything that can be done to avoid another claimant coming forward?
Sure. As with most resolutions or settlements of cases, the client is always interested in making sure that they're buying some degree of peace. And again, I'm trying not to tread on too much of the confidential stuff that we have in mind, but there are certain provisions that you can try to put into some settlement agreements, assuming you're reasonable and obviously acting within ethical boundaries, that might get you a little bit of that peace. So, for example, while you can't ask a lawyer not to represent another client suing you, and I think, as you will see, a lot of these are one-off lawsuits, not class actions, there are other provisions that you can perhaps discuss that would provide a little more comfort that you're not going to see another lawsuit down the line right away or at all. There are other options that you can pursue from a business standpoint in terms of getting yourself into compliance before the letters of the lawsuits even start flying as well, which Elena touched on and you touched on earlier.
Great. Go to the next screen. So, Elena, do you want to kind of sum up some of the sort of best practices or closing thoughts and pointers we have for the audience?
Sure. Can you hear me?
Yep.
So I think the bottom line is it's likely this issue is not going to go away. So as businesses and institutions, we need to proactively engage both inside and outside people to figure out what you need to do and how quickly it can be accomplished. Now, I also think there needs to be an acknowledgement that this all gets done in stages. There's no magic wand in this space. and if your companies are similar to mine, the marketing team turns over at the speed of light, so you're constantly retraining. And I think there's going to need to be more focus on a go-forward basis on how to really work within the mobile app space, because the technology changes, I think, at a little bit quicker a pace. We also recommend that you start reviewing your contracts and how you interact with your third-party vendors and contractors to ensure that what they're developing on your behalf meets your company standards and the policies that we would recommend you develop in terms of what you want to be and do as a company. We also have been, and I think we're back to Chuck, to figure out, how he recommends his clients do a risk assessment. But for Duncan, the risk assessment was to continue to get sued or to make changes. It seemed like a no-brainer to make the changes as opposed to continue to get sued in various states. And when you do business in every state, you can't rely on the Ninth Circuit being different from the First Circuit. You just have to look at it on a national basis.
Right, and just to add to what Elena said, I mean, of course, if it's a business being sued or receiving one of these demand letters, the business will have to weigh, first of all, from an economic standpoint, whether it's worth the cost and expense of fighting the case, of defending it through summary judgment or trial. They, of course, also have to factor in other things as with any litigation, negative publicity, disruption of the businesses, employees to the extent they have to be involved in the litigation. So, all of that will have to be factored in. And then as Jeff said, there are certain things that Jeff and I have done in the past to help try to minimize the risk of there being, repeat plaintiffs or future claimants. You can't absolutely foreclose that, but there are certain things you might be able to get in a settlement to help with that. Well, I'd like to thank the panel very much. We do have a little bit of time for questions. I guess we have about 7 minutes or so, and a few have come in. And let me read. The first one is, are best practices the same for a business-to-business website that does not target nor allow consumers on our application? I'll start, and then, Jeff and Elena, if you want to jump in, feel free. But I guess a couple of thoughts here. So, it may depend, when you say it's a business-to-business website, the ADA primarily protects individuals with disabilities. So to the extent that it's a corporate entity or some other entity, obviously other than an individual, that entity may not have standing to assert a claim. But if it's an individual sole proprietor who's in business and is trying to navigate through your site and having difficulties because it's not accessible to disabled individuals, then you might have a problem. But another issue might be whether it's actually a public, so-called public accommodation or place of public accommodation. I have seen a lot of businesses have password-protected websites where really it probably is not a public, website. Somebody would have to log in with a customer number or ID, and I think that might limit the exposure as well if that kind of extra layer is put in place. I don't know if, Jeff, you have anything else on that.
Not really. I would point out that Title I applies to employees and requires reasonable accommodations. So to the extent it's a business-to-business website, you have an employee that needs a reasonable accommodation to use the website, you may have an obligation to help them be able to look at that website or listen to that website or whatever the case may be.
Yes, very good point. Another person on the program or on the attending asked if Elena could provide the consultant. And Elena, you did do that. If you don't mind maybe repeating which consultant Duncan has been working with.
So we work with WGBH, and it's the Carl and Ruth Center for Accessibility in the Media. And you can actually just go on WGBH.org and link through.
Right.
But
I think it's Carl and Ruth Shapiro or Shapiro. Go ahead.
So,
yeah,
but there's other companies as well. They were local. What attracted us the most is they were local. We're only about 40 minutes, and they're willing to come down to our headquarters and meet with our development teams. And we've also sent our development teams into their office, which has been helpful versus me ask a question, myself get an answer, have to relay it back and forth. I've been able to have people meet in person and go through the different technologies and say, hey, this is one reader, how is this going to work on this application? And the proximity was really a benefit for us. I'm sure there's people in other parts of the country that provide the same services.
Right, and as Elena said, there are other consultants. Jeff and I are aware of some, and if those on the line want, we can send out, some other organizations that offer those kinds of consulting services. We've seen a few other clients of ours use some other entities, and some of the plaintiffs' lawyers have some that they prefer, but there are different organizations in different parts of the country that do provide these services, and we'll probably see a lot more of them, given the amount of litigation we're starting to see.
And there's also some online tools that you can use as a preliminary basis to go through your websites to see how they behave and give you some preliminary readings as well.
Yeah, and we could send that out also. That's a good point, Elena. Somebody asked, in this context, what does it mean to be, quote, properly coded, close quote? And I don't know, like in Elena, I think it probably depends on the particular website, but Elena, I don't know if you can shed any more light than what you've said already.
So go with I'm repeating what I've learned from other people. There's a certain way when you set up your hierarchy that people who are navigating without a mouse have to be able to read the different headlines, and part of that is how the hierarchy is coded. And I don't think it matters on the platform. Each platform has a way of expressing itself so that different readers can get the information and be able to navigate the site. So within, our privacy policy, initially it wasn't entirely ability to be read by a text reader. It would jump you to different sections out of order. We had to go in and reprogram it so that it read it chronologically and that a text reader could flow through the different policies and terms and conditions. It wasn't something we ever had run a test on to know whether we could. Once they brought it to our attention, obviously we fixed it very quickly. But there's things that the agencies do on the back end to allow the different navigation tools and readers to operate properly. I hope that helped.
No, thank you. Now, somebody else asked about what language can we put into settlement agreements to attempt to stop future suits, and I know we're kind of running short on time. So it kind of varies. There's state rules of professional conduct. I mean, Jeff alluded to the fact that you can't necessarily prevent a lawyer from representing another client with the same issue or claim. But, there are certain representations you could obtain from the plaintiff and from the plaintiff's counsel as to their knowledge or lack thereof of other claimants with this issue. There might be some cooperation language you might be able to develop. We've had some success here and there with certain provisions that, we felt at least gave our clients a little bit more protection than you might normally get from a regular kind of settlement agreement and release. So, we'd be happy to speak further, with anyone after today on some specifics there. But there are, we think there are, in our experience, some things you can do to at least help in that regard and to help minimize perhaps the chance and that there might be future repeat lawsuits. Well, I think we're just about out of time. We have a couple other questions that I don't think will be possible to address in the 30 seconds or so we have remaining. But we'll endeavor to try to get answers out to those who ask questions that we weren't able to get to. But I want to thank Elena very much for agreeing to participate with us in this program. I think it really was great to have the in-house counsel's perspective. And I thank my colleague Jeff for also, of course, adding so much to the program. And I thank all of you for attending.
And I have the last two CLE words for your credit today. So our first word was website, and our second word was Hamilton. So the third word is going to be pepper, and the fourth word is compliance. So again, the third word is pepper, and the fourth word is compliance. And I have put up my email address here to request the CLE form, so just go ahead. If you would like CLE credit today, contact me and I will get you squared away. Okay, so thank you. Thanks for joining us, everyone.
Thank you, everybody.
Bye.